What is up, everyone? Welcome to Engineering Law, Lecture 2. Engineering Law, Lecture 2. Okay, last time we're talking about construction contracts. Today, we're going to continue on that thread. Okay. So the guaranteed maximum price plus bonus. Like the cost plus bonus contract, the guaranteed maximum price contract incorporates an incentive to the contractor to effect savings on a cost-plus project. The contractor receives a fixed fee as well as an agreed-upon percentage of savings. The guaranteed maximum price contract offers the owner a further advantage over a basic cost-plus contract. The guaranteed maximum price feature. The amount of the guaranteed maximum price should be determined on the basis of detailed plans and specifications rather than on the basis of a reasonable estimate. Again, the owner usually expects the engineer to advise on the reasonableness of the contractor's maximum price. Number 5, the design-build contract. With this type of contract, it is normally the contractor rather than the owner who arranges to obtain the necessary engineering design services to finalize the design detail. The detailed design is often finalized as the construction work proceeds. The construction may proceed promptly. Detailed plans, specifications for subsequent phases are finalized at a later date. The work often proceeds on a cost plus bonus basis. This appeals to owners who wish to avoid retaining professionals. In design-build contracts, the engineer is usually the agent of the contractor, but the contract normally entitles the owner to retain, at its option, in its own engineering representative. The owner's engineer will double-check the sufficiency of the design services provided. The engineer will also be expected to ensure that construction proceeds in compliance with the agreed-upon plans and specifications. Project management. The design-build contract is often used in connection with projects that are organized on a project management basis. The owner usually enters into a contract with a project manager. The project manager acts as the owner's agent and acts on the owner's behalf to arrange for professional design services and to hire contractors to complete the construction. The project manager usually purports to have the experience and contacts necessary to facilitate and expedite the design, tendering, and construction stages. In return for acting on the owner's behalf, the project manager receives a fee. This fee is in addition to the professional design fee and the contracting cost, which the owner would incur in any event. The project manager simplifies the construction process for the owner. Theoretically, the project manager's fee is the premium the owner is prepared to pay in order to receive the advantages of the project manager's experience, contacts, and administrative expertise. Hiring a project manager may, in fact, lead to overall cost savings of the project. Prime contract and subcontracts. Where the owner enters into a construction contract and with a general contractor who in turn enters into subcontracts with various trade contractors, a contractual relationship called Privity of Contract exists between the owner and the general contractor. Privity of Contract exists between the general contractor and each of its trade subcontractors, but no Privity of Contract exists between the owner and any of the subcontractors. The administration of the contract between the owner and the general contractor should be consistent with the administration of the contract between the general contractor and each of its subcontractors. To ensure consistency, the general terms and conditions of the head contract between the owner and the general contractor should be included in each of the subcontracts wherever applicable. If this consistency of terms and conditions is not achieved, there is no assurance that the general contractor will be capable of passing on to the subtrades the engineer administrator's decisions. Inconsistency increases the likelihood of contract administration difficulties. For example, suppose that mechanical extras are authorized for and valued by the engineer pursuant to the terms of the head contract, and suppose that the general contractor does not provide in the mechanical subcontract that extras are to be valued by the engineer. If the mechanical subcontractor disputes the value of the extras, unnecessary difficulties may well arise. The subcontractor may be entitled to claim an amount for the extras in excess of the engineer's valuation. The general contractor will then have a problem which may conceivably adversely affect and otherwise smooth contract administration. The engineer administrator can promote smooth contract administration by ensuring that the general contractor is aware of the need for consistency in the general conditions of the head contract and the general conditions of each subcontract. Delay and interference claims. Claims by contractors against owners for damages resulting from delays and interference caused by the owner's representative are not at all uncommon in the construction industry today. Claims on account of delay may result when inquiries from the contractor are not properly answered. The contractor may be required to delay construction until receiving a reply to his or her query. Claims of interference result when the works of subcontractors overlap or when a project is not well coordinated. The engineer administrator should ensure that responses to contractors' inquiries are provided promptly and that the overall project is coordinated to minimize delay and interference claims. Compliance with notice provisions. The entitlement of contractors to time extensions or other relief for unforeseeable or excusable delays is usually conditioned upon the contractors giving written notice of delays within a contractually stipulated time. As a general rule, the courts have not been very forgiving. They have strictly interpreted provisions of contracts requiring timely notice. For example, in the case of Corpex 1977 Inc. versus Canada, a decision of the Supreme Court of Canada, an excavation and construction contractor undertook by contract with the Crown to build a dam. After completing the project, the contractor brought an action claiming for the costs incurred due to mistaken information provided by the Crown's engineers regarding the nature of the soil, and for the costs resulting from delays and disruptions caused by the performance of work at the request of the owner's engineer, in addition to that provided for in the plans and specifications, i.e. for extras. The Supreme Court allowed the claim for the extras because there was no notice provision in the relevant contract clause. With regard to the costs due to the mistake regarding the nature of the soil, the contract allowed for reimbursement of additional expenses, conditioned on written notice of the claim being provided by the contractor within 30 days after encountering the soil conditions giving rise to the claim. Justice Beets, writing for the Supreme Court of Canada, held that since the contractor did not provide the requisite notice, but rather waited until completion of the contract, the contractor's claim could not succeed. Justice Beets explained that the soil conditions reimbursement clauses provided benefit to both the contractor and the owner. The contractor was assured of recouping its additional costs if it complied with the notice provisions, and the owner could at that time have decided whether to continue with the project or to rescind the contract. However, if the contractor waited until the work was complete before claiming for reimbursement, the contractor then deprived the owner of the contract rescission benefits that the contract expressly provided for the owner. The lower courts have followed the lead of the Supreme Court of Canada in strictly construing the notice provisions of contracts. In the case of Doyle Construction Co. versus Carling O'Keefe Breweries of Canada Limited, the British Columbia Court of Appeal considered a contractor's claim for impact costs incurred by the contractor as a result of the owner's delays, interference, and changes of the work sequence. The contractor contended that it could not ascertain the cumulative impact costs until the completion of the construction, when the claim was finally made. Along with other reasons for dismissing the contractor's appeal, the appellate court found that the trial judge had correctly rejected the contractor's claim because the contractor had failed to comply with the terms of the contract requiring the claim for damages to be made in writing within a reasonable time after the first observance of such damages. In the case of Acme Masonry Limited versus Byard Construction Limited, just 1 second here. A subcontractor entered into a subcontract with the defendant, general contractor, who was to construct a courthouse. As a result of labor unrest and the unavailability of certain materials, the performance of the subcontract was delayed for several months beyond the original schedule. The subcontractor accepted the revised schedule but gave notice in writing that it intended to make a claim beyond the amount of the subcontract as a result of the delays. By the terms of the subcontractor was required to set out its claim fully in writing within a reasonable time after the first observance of the damages claim, and not later than the time of issuance of the final certificate. The British Columbia Court of Appeal held that, notwithstanding that the subcontractor had put the contractor on notice that it would be claiming for the additional costs, the subcontractor's claim was statute barred, as it had failed to submit the detailed claim before the date of the final certificate. Notice of the notice was not sufficient. The notice had to be provided on time. However, notwithstanding these cases of strict judicial construction of notice provisions, a 1987 decision of the British Columbia Supreme Court appears to have broadened the court's interpretation of what constitutes notice. In the case of W.A. Stevenson Construction Western Limited versus Metro Canada Limited, the plaintiff was the general contractor for the construction of a portion of the Vancouver Light Rapid Transit System. The construction contract with the defendant developer provided for 6 milestone completion dates within the overall contract time and an agreed completion date for the whole contract. The contractor brought an action against the developer claiming $4.6 million in damages for breach of contract on the basis that it had been delayed by not being given full access to the construction site, and then forced to accelerate construction to maintain the tight schedule. The court found in favor of the contractor. The court found as a question of fact that the developer had failed to provide the contractor with the unobstructed workspace called for by the contract, failed to provide time extensions to which the contractor was entitled due to the obstructed workspace, inclement weather and labor problems, and failed to provide timely and accurate information concerning factors adversely affecting the contractor's planning. The effect of these failures was an interference with the contractor's efficiency, disruption of the coordination of its construction operations, and a loss of its productivity, all resulting in a loss of the opportunity of making the original profit. In a departure from a strict construction of notice provisions, the court held that the contract terms requiring the contractor's timely written notice of delays and extra claims, or the developer's written waiver of its rights to require such a formal notice, did not bar the contractor's recovery, despite the lack of any formal notice or written waiver. The court determined that constructive notice of the contractor's problems was provided to the developer by the contractor in the form of miscellaneous written communications and detailed minutes of the meeting. The court observed, "A reading of the minutes is very revealing. They were obviously regarded by everyone as a method of formally communicating their concerns to the other party. Accordingly, the intention of formal communication between the parties was sufficient to constitute notice, notwithstanding non-compliance with the formal procedure of written notice. The Stevenson decision confirms that it is not the form of the notice that is the governing factor. What is important is whether enough information has been provided to the other party to satisfy the purpose for which notice is required, such as the financial significance of the claim and how to mitigate its impact." Failure to give notice of a claim will be less likely to be fatal to the claim in question if the notice provision doesn't include express wording to the effect that procedural non-compliance extinguishes the claim. Our courts have also confirmed that whether or not the other party has been prejudiced by the procedural non-compliance is a key consideration in determining whether non-compliance with the notice provision is fatal to the claim. In this regard, see the 2002 decision of the British Columbia Supreme Court in Golden Hills Ventures Limited versus Chemists Mines Inc., where the court found as follows: "Even if there was a requirement for Golden Hill to provide notices of claims, the failure to do so did not prejudice Chemists, I am satisfied that this is not a case where a claim was unexpected. As early as July, Chemists was aware of the problems Golden Hill was facing, of the impact of the problems on the operations of Golden Hill, of the general financial impact of those problems, so that Golden Hill would likely be making a claim. Shit. Okay, now we're going to change the subject a little bit. We're going to go to partnerships and corporations. For no reason, we're going to change to this. Totally didn't close the book. The regulatory provincial common law statutes provide, in effect, that a partnership or corporation may be granted a certificate of authorization or be permitted to practice professional engineering, providing such professional engineering is practiced under the responsibility and supervision of a member or of a licensed professional engineer, and otherwise complies with the applicable provincial statute and regulations thereunder. Disciplinary hearings. The regulatory statutes also authorize what disciplinary action may be taken against members or licensees for professional misconduct. Disciplinary action usually arises in Ontario, for example, following the submission of a complaint to the Complaints Committee. The committee examines the complaint and can then refer the matter to the Discipline Committee. The Discipline Committee is authorized pursuant to Section 28 of the Professional Engineers Act, when so directed by the Council, the Executive Committee, or the Complaints Committee, to hear and determine allegations of professional misconduct or incompetence. Disciplinary action may result in reprimands, suspensions, fines, and cancellation of membership and licenses. Decisions of disciplinary hearings may be appealed to the courts in accordance with the provisions of the applicable regulatory statute. Penalties. The offense provisions of the statutes that regulate engineering impose varying penalties for contravening statutes and ordinances. The penalty in Ontario, for example, for practicing professional engineering without a license or for holding oneself out as engaging in the practice of engineering without being properly licensed, includes a fine of not more than $25,000 for the first offense, and for each subsequent offense, a fine of not more than $50,000. Certificates of authorization. So that's pretty bad. If you do illegal engineering, you can get fined up to 25 grand, then 50 grand, and then always 50 grand after that. Certificates of authorization. In Ontario, professional engineering membership alone does not qualify engineers to offer to the public or engage in the business of providing to the public services that are within the practice of professional engineering. A certificate of authorization is also required. Applicants for certificates of authorization, including individual members, partnerships, and corporations, must meet prescribed requirements and qualifications pursuant to the Professional Engineers Act. The registrar is authorized to refuse to issue to suspend or to revoke a certificate of authorization where the registrar is of the opinion upon unreasonable and probable grounds that the certificate should be refused, suspended, or revoked upon the basis of past conduct or failure to meet requirements or qualifications. All holders of certificates of authorization must have professional liability insurance, subject, however, to certain exceptions pursuant to Section 74 of the regulations. Minimum coverage for each single occurrence must be not less than $250,000, with an aggregate policy limit for all occurrences of not less than $500,000 per year, or alternatively, an automatic policy limit reinstatement feature. Any engineer who obtains such insurance should ensure that it complies with all the requirements of the regulations. Section 74(2) of the regulations provides for certain circumstances in which a holder of a certificate of authorization is not required to be insured, including circumstances where insurance is not available, i.e. nuclear hazards, and where written authority from the client for professional engineering services to be performed without insurance is provided. Regulations, like statutes, may change from time to time. It is most important for professional engineers to keep informed of current professional liability insurance requirements under their governing provincial statutes and regulations. Okay, now we're going to talk about overlapping in the scope of engineering and architectural practices. As noted, the term professional engineering is broadly defined by the regulatory statutes and ordinances. Occasionally, the broad definitions lead to confusion. One problem is the distinction between the functions of an engineer and an architect. The problem has been considered by the courts. For example, in 1939, the court heard Rex versus Bentel, a professional engineer in British Columbia, and had planned and supervised the construction of a theater. He was convicted for unlawfully practicing as an architect. In 1955, the Ontario County Court heard Regina versus Margeson and Associates Limited. An engineering firm was charged with holding itself out as an architect. The court examined both the Professional Engineers Act and the Architects Act to decide whether a particular job was essentially one for an engineer or for an architect. But neither act provided the court with definitions specific enough to distinguish between the two professions. The action against the engineer failed. The court stated in part, "I cannot but think that it was the intention of the legislation to give reciprocal privileges, at least to the extent necessary to cover the facts disclosed, and that it is up to the client to weigh the qualifications of firms of architects and engineers and decide which he wishes to employ. Or indeed, if he wishes to employ both, which is a common practice. Mr. Fleming contends that it is possible to decide whether a job is essentially one for an architect or one for an engineer. I can find nothing in the words of the legislation which enables the court to draw such a line between the two professions. I do not think that the court should endeavor to do so until the legislature passes appropriate provisions." Okay, now we're going to talk about background to changes in Ontario legislation. In Ontario, however, the Professional Engineers Act includes provisions intended to simplify the scope of practice dispute between professional engineers and architects. The provisions describe the nature of construction projects that can be designed by engineers alone, or by architects alone, or by both. The provisions were worked out by representatives of the PEO and the Ontario Association of Architects, OAA. Premised on two particular declarations of principle, agreement was reached. The first premise, engineers should confine their professional activity to the practice of engineering, and architects to the practice of architecture. The second premise, a client should be free to select the prime consultant of the client's choice. The PEO-OAA agreement and the decision of the Professional Organizations Committee contemplated in part that a joint practice board composed of 3 engineers and 3 architects appointed by the PEO and the OAA respectively be instituted. The board would be authorized to make recommendations to the PEO and the OAA and to handle complaints of an interprofessional nature. It would also be empowered to work on other matters such as the coordination and publication of guidelines, standards, criteria, and performance standards in the field of building design and construction. The recommendations of the Professional Organizations Committee were implemented and resulted in revisions of regulatory statutes governing both engineers and architects. Section 47 of the Professional Engineers Act of Ontario now provides for a joint practice board composed of a chair, 3 architects, and 3 professional engineers who are authorized to recommend the issuance of licenses. Firms are now entitled to practice both professional engineering and architecture. The joint practice board is also authorized to assist in the resolution of scope of practice disputes. Sections 47.4 and 47.5 of the Professional Engineers Act provide 47.4, where a dispute arises between an architect and a professional engineer or a holder of a certificate of authorization as to jurisdiction in respect of professional services. The registrar may refer the matter to the Joint Practice Board, and the Joint Practice Board shall consider the matter and assist the architect and the professional engineer or the holder of the certificate of authorization to resolve the dispute in accordance with the rules in Section 12. Proceedings shall not be commenced under this Act in respect of the matter mentioned in subsection 4, except upon the certificate of the Chair of the Joint Practice Board that the Board has considered the matter and has been unable to resolve the dispute. Litigation versus disciplinary matters. As previously explained in the text, in order for a professional engineer to be liable for tort remedies or for the remedy of damages for breach of a contract involving a duty of care, such as a contract for engineering services, it is necessary for damages to have been caused by the engineer's negligence. Whether the lawsuit is in tort or contract, as is more likely to be the case in both. Bum bum bum. How dare they? To more briefly state the concept, damages having been caused by the negligent engineer are a prerequisite to the defendant engineer being liable in such a lawsuit. Such is not the case, however, as far as disciplinary proceedings under the Professional Engineers Act are concerned. Damages are not a prerequisite in disciplinary proceedings. Disciplinary proceedings under the Professional Engineers Act usually proceed in the form of allegations of professional misconduct or incompetence. In this regard, Section 72 of the regulations under the Professional Engineers Act set out a definition of negligence and an extensive description of conduct that amounts to professional misconduct. Not surprisingly, negligence is defined to mean an act or an omission in the carrying out of the work of a practitioner that constitutes a failure to maintain the standards that a reasonable and prudent practitioner would maintain in the circumstances. Obviously, the definition of negligence is tied to the measure of the duty of care that a court would apply in a lawsuit in determining if the professional engineer had been negligent. Accordingly, any conduct constituting negligence by tort standards will also constitute professional misconduct. Accordingly, the disciplinary process under the Professional Engineers Act provides for circumstances in which a professional engineer who has been negligent can be sanctioned even where damages have not been a consequence of the Professional Engineers Negligent Act or omission. For example, where it could be substantiated that a professional engineer had negligently prepared drawing specifications, the professional engineer could face disciplinary hearings even though construction of the structure described by the drawing specifications had never taken place. Professional engineering is a self-governing profession. The disciplinary process provides sanctions that can be applied independently of any lawsuit and is therefore a very important basis upon which the provincial bodies may govern in the interests of maintaining professional standards to ensure that the public interest is served and protected. Alright, my friends, that's all we got for today. Hope you enjoyed that. Stay safe.